Do not ask me to remember. Don't try to make me understand. Let me rest and know you're with me. Kiss my cheek and hold my hand. I am confused beyond your concept. I am sad and sick and lost. All I know is that I need you to be with me at all cost. Do not lose your patience with me. Do not scold or curse or cry. I cannot help the way I'm acting. Can't be different, though I try. Just remember that I need you. The best of me is gone. Please don't fail to stand beside me. Love me till my life is done. Alzheimer's, a fatal disease that is a main killer in seniors in the United States. 1 in 3 seniors die with Alzheimer's or another form of dementia. Hope is not lost even though a cure has not been found. Care for patients in the United States estimates around $236 billion. Help with the fight against Alzheimer's today by bringing awareness to this deadly disease.
Welcome to You and the Law, a program produced by the Chicago Bar Association that explores a variety of substantive legal topics and matters of public policy that are of interest to the general public. We have with us today a very special guest who I'm very happy to say has been with us multiple times. I'm starting to lose track, and I really appreciate the insight that he and some of his colleagues, have shared over the past few years. This is Dr. Tom Ginsburg from the University of Chicago, and he, does many things. We've got into the background on other shows. I'd like him to introduce himself in just a moment and perhaps share some whatever he thinks might be most relevant for today's topic in terms of what he brings to the table in his background. And today's topic is one of some real weight, and one that I think people like Dr. Ginsburg are incredibly helpful to the public and to the bar associations, to lawyers. He's an educator and a scholar on topics of real relevance that have proven to be challenging for the average person to navigate. And I can tell you, someone who has some closeness to the issue, even professionally, it is challenging to discuss it. Without getting into the merits. There are social challenges sometimes with discussing it. And when we have that, it's very important, I think, to have people like Dr. Ginsburg who can shed some light on things so we can discuss it in the most enlightened way. So with that, I could go on, but I shouldn't. I really thank you for being here again. I'm going to turn it over to you, Dr. Ginsburg, to share some background and get us started on our discussion here. On of course, and what are we talking about? We're talking about the ICJ opinion related to the occupation of Palestine, of occupied territories of Palestine, and the legal implications from the United Nations International Court of Justice. So that is our topic, and it's one of significance. And we're also doing this while the DNC is going on. It's just it's in the air and what's going on right now. So I really appreciate you for being here now, and please go ahead.
Thanks so much, Michael. It's always a joy to speak with you. And yes, this topic today is the decision which came down last month from the International Court of Justice on the legal consequences of the Israeli occupation, the legal status of the Israeli occupation that began in 1967 with the taking over the territory of the West Bank and Gaza. And this was it's obviously very timely, given that this has been an issue of major public import, certainly since October 7th of last year. Actually, the request for the advisory opinion was filed before that. And so it doesn't even deal with anything that's happened since October 7th, but it is part of the broader context for that conflict, obviously.
Right. Good
So maybe that's
context,
all I'd
right?
say at the beginning. I just want to, just personally, there's two angles at which I come at this. I'm a comparative constitutional lawyer and I teach international law and international human rights, but I'm also
Right.
very interested in free expression. And so in the last year, I think it's been very important that we have as many fora as possible to discuss and learn about the history of this conflict and talk about how to resolve it,
Mhm.
on campuses and beyond. So that's an interest of mine as well.
And I want to thank you right away too, because I've been to at least a couple, if not more, of the programs that you've been a part of at University of Chicago on this and related issues, including speech, which have been wonderful. So that's been great. Thanks. Can you tell us a little bit before we jump in, because we've done some speech programs. Can you tell us? Because it's part of what we're doing here is getting into the issue. So just at the outset, can you say just something about speech and the importance of discussing these topics that we're about to delve into?
Sure. So I run something called the Forum on Free Inquiry and Expression at the University of Chicago. It started, actually, we launched on October 6th last year, of all dates. And, one of the things we really want to do, and it's a big challenge in our era, particularly for students. I mean, many of your viewers, of course, are lawyers. They might have kids and such. And, I think it's just a really difficult time to be a young person in a social media era because you tend to talk only with your friends. There's this reinforcing thing about social media. We don't often get to the opportunity to speak in person with people we disagree with or hear that happen. And it's just a central skill for democracy. So we think that, we need all our students and our faculty to be able to do that and to promote as many opportunities for that as possible. But we're also very concerned with the increasingly repressive environment for academia or in academia. And, there's all these bills that are being passed in various states that are limiting what can be taught, that are interfering with tenure. There's an internal, I would say, illiberalism that's brewing in academia. We also have to push against that, and this last year we've seen a lot of that. So that's part of our overall mission.
Sure. And I can tell you too, I mean, I'm not in an academic setting the way you are, but I've taught at 2 law schools over the last 10 years. And I have a sense for sort of a little bit of the culture there. And I also serve there in other capacities. So just in terms of just appreciation for what goes on at school, and my own attraction to it, which is trying to understand these things, which on some level, viscerally just cause a little bit of anxiety. But as lawyers, I think it's kind of part of the excitement of what we do. And I think it gives it some meaning. So I don't want to go too much further with that, but I think it's important. And I think that's embedded in the speech and thought issues. So with that, let's turn to the opinion and perhaps just a little bit of background on the court itself and its context.
Right. So the International Court of Justice is the judicial body of the United Nations. It was set up at the same time. And it is sometimes called the World Court. It is not a court of general jurisdiction. This is critical. It's a court which decides cases which are sent to it or assigned to it by treaty. So in many ways, it looks a little more like an arbitration type of body. In fact, if you're a state that hasn't appointed a judge to the court, you get to appoint a judge if you are brought before the court in a case. So there's a lot of consent basis for it. That's what it does in general, but it also has
and that structure is not familiar to most lawyers who even spend their entire career in a courtroom. I just point that out because I've been doing that for almost 20 years now. That is unfamiliar to me in a lot of ways, and I do see the elements of arbitration, other sort of dynamics that enter it, just generally.
Yes.
But go ahead.
Right. So it's decided, well over 100 cases involving 2 states. And I've written about when it's effective and when it isn't. And, many of these decisions are complied with, some are not. But this particular decision is what's called an advisory opinion. So in the United Nations Charter, it does allow advisory opinions. Now, American lawyers know, Ground Zero, John Marshall, it says, no, we don't do advisory opinions. The Supreme Court does not do advisory opinions. We only do cases and controversies, active cases and controversies. But that's not true in many other courts or constitutional courts around the world. So what's an advisory opinion? It's an opinion which says this is the state of the law. And for the International Court of Justice, the entities which can ask the court to do that are not states, actually. They're organs of the United Nations or certain international bodies. So in this case, it was the General Assembly, but the Security Council could do this. Certain, UN organizations, the Economic and Social Council, have done it before. So Anyway, it's a kind of internal clarification of the state of the law. Doesn't produce a binding opinion. It's merely declaratory, but it can have impact because it helps coordinate the reactions of states. And in this particular conflict, where so many of the terms, apartheid, genocide, self-determination, they're kind of vague, and they get wielded in lawfare. They get wielded as epithets sometimes. A court can help to say exactly what's going on, and that can help improve discourse.
Sure. And I just want to spend a very brief moment now, because now we're going to kind of jump in a little bit more to the substance of things. And thank you for that context. But I think at our core, just as lawyers, it's just good for me to just think, just as a matter of good practice, the part of our responsibility. There's, I think, authority for this, but we'll consider it just me saying it loosely, is to increase the quality of the discourse where possible, while being highly zealous advocates on issues that are serious. So that I think is the tension that we navigate. That's the heart of the practice in some ways for me, so close to it at least, is reconciling those things.
Just a brief comment on it. I mean, it goes back to your earlier introduction. I think lawyers have this very special role to play in democracy in our legal education, because we are training. Right. We should be trained to argue whatever position we can, our client has zealously, whether or not we agree with that. And that requires the intellectual, it requires empathy, it requires the intellectual ability to switch sides and analyze the argument. And I think those are skills that the society is in desperate need of, and lawyers should play a role in protecting our democracy by fostering them. So
yeah. And I can tell you it's hard, because it's about reconciling internal conflicts between some passion and also your logic and reason and sort of enlightened touch that we hopefully bring to the practice in service of democracy. So without going further in that regard, let's get to the opinion, however you'd like to approach it, because there are many aspects to it.
Yeah. So I'll read the question that the General Assembly asked the court to decide. What are the legal consequences arising from the ongoing violation of Israel of the right of the Palestinian people to self-determination from its prolonged occupation, settlement, and annexation of Palestinian territory, et cetera? And it goes on and on. It talks a little bit about the policies of Israel in altering demographic composition, status of Jerusalem, and discriminatory legislation. So it's a broad kind of, indictment of the Israeli occupation. And that requires, of course, the court to figure out what's going on. And, some of these things, I think, from an international law perspective, are actually pretty easy. And there was broad agreement on the court. There's a lot of separate opinions, though, and it's rather interesting this way. There's, I think, 15 different opinions. So there's a main opinion of the court, which, has some aspects which are decided 15-0, some are 14-1, and then a number are sort of 11-4 and such. And so there's a fragmentation in terms of the legal analysis on some questions. And then there's, I read a lot of these opinions. They're all quite thoughtful, but some of the questions are really easy, and the court, does get unanimous agreement. So let me go through it. The first thing that they have to grapple with is, do they have jurisdiction? It says the UN charge says the court may issue an advisory opinion upon request, which implies some discretion. And I think the United States, in its appearance before the court, and I should add that there were 50-something states that made appearances before the court. This was like a full employment act for international lawyers, because there were so many presentations made. But the United States argued that the court should not issue the advisory opinion. It was interfering with an ongoing political conflict and things like this, and was going to make things worse. And there is one judge who voted, who thought the advisory opinion should be issued, but then voted against the court on every single issue. The judge from Uganda, she has consistently said this is a political question. This lawfare is not helping, and she doesn't, think that the court should weigh in. So that's her view.
I like to hold there for one moment, because you have two subpoints that I just want to highlight, if I can remember them. But one is, there is definitely law and policy. There is, whether you want to call it a gray area or some place where it's not necessarily evident, at least to me, what category we're falling into. So that's one of the things that I think is navigated when we think about rule of law in the context of democracy and sort of how it operates practically. The other thing associated, which I may have lost at this point, let's not focus on it because you have much more to say, and I'll just turn it right back to you on your thought. Go ahead.
Okay, well, so one question on which I think it's very easy for international lawyers is the question of self-determination. Do the Palestinian people have a right of self-determination? The answer is clearly yes. They're a people, self-determination, and this opinion says it is a peremptory norm of international law, one that cannot be denied. And so there, they focus, they mention in passing the law within Israel, the nation state law, which was passed in 2018 by the Netanyahu coalition, which says that only the Jewish people has the right to self-determination. And from an international law point of view, that's wrong. Palestinian citizens.
It's inconsistent. Sorry about that. It's inconsistent with the Declaration of Human Rights and for sort of every aspect, the Universal Declaration of Human Rights, that kind of position, and every sort of aspect that reinforces, I believe, about self-determination. Right.
But the critical thing here is self-determination does not mean that every people gets its own state. That could mean endless fragmentation of states, but it does mean you do get the right to determine your own affairs. You get the right to speak your language, to practice your religion, and many states have violated this and continue to violate this for many ethnic groups. This is a big problem. But the idea that the Palestinian citizens of Israel don't have self-determination is clearly wrong. They have the right, like any minority would have certain rights of self-determination. So that was a pretty easy case. But then the question of the nature of the occupation and what to do about it. And that's harder because the law of occupation, of course, is a longstanding feature of the law of war. It gets codified in the Hague regulations of the early 20th century and then in the Geneva Convention. There's all kinds of rules about what you can do in occupation. But it's recognized the fact that sometimes you do need to occupy territory. In war, you conquer territory and then you are administering it. And the conception of occupation is as a temporary thing. We're just going to hold this until the war is over, and then we will return it, hopefully, to a new regime of our enemy that is willing to live in peace.
And whether anyone agrees or disagrees with that dynamic and whether it's appropriate is a totally different question than the fact that it's a recognized dynamic with legal implications. Does that make sense?
Yeah, and it's called international humanitarian law. The Fourth Geneva Convention of 1949 lays it out in detail, like everything you can do. And the nature of that law it basically says the occupying power is supposed to protect the civilian population and preserve their rights and not change the character of the occupied territory. That's the critical thing here. Particular case. That is, you're supposed to govern it for the benefit of the population, not exploit the natural resources for for your own benefit, and return it to as soon as practicable, meaning when the war's over. Presumably, when your enemy is defeated and surrenders, then the people get their land back and they can live there. So, of course, part of the
before we jump into that, and I really hate to interrupt you at any time, but I just wanted to bring up because I remember that prior point, and we don't have to go back to it generally. But the jurisdictional issue, the way you described it, and my understanding coming in, and just as a lawyer, we know this jurisdiction is not perfunctory. It's a big deal. And that's a big aspect of this case. It actually seems to me, as someone that does not have the level of sophistication that you do with some of these books, I would like to talk about if we have time later. But, that opens up a larger discussion that is into the realm of political science and sort of larger themes that I think are not exactly the rule of law, technical issues, if that makes sense. So that's sort of the spectrum. I'm trying to stay on the law side of things.
I understand. And I think that, but law is always interacting with, reality and, And, question, there's a tension. I mean, this is a very big, actually kind of deep point you're hinting at, because the law isn't outside of society. It's in tension with international law in particular, has to reflect what states would reasonably do under their, under their circumstances. And those rules which kind of fit what enlightened state interests would allow, those are the rules that tend to survive. That's where international law is effective. And those which demand things of states which they couldn't reasonably be asked to do
Right.
tend to be, they're ephemeral and they don't have any bite. And so there is a tension between.
So there's realism. There's
yes,
realism
I think there's
embedded
realism
in it.
built in my view. And thus it's there's clearly law that gets set, but is it reasonable to ask an occupying power to temporarily occupy the place, return it in trust for the people who happen to live there, and with the ultimate vision for allowing their self-determination? I think that's pretty reasonable. But sometimes occupying powers change the character, and actually the United States did this a little bit with the occupation of Iraq after 2003, one of the very few instances where states have acknowledged that they're applying this law of occupation. But of course, we changed the political regime fundamentally. But I think people are like, well, yeah, but it's better for the Iraqi people, so it's okay. But what's happening, of course, in the West Bank and Gaza is not that kind of thing. And the court talks a lot about sort of de facto annexation, or even de jure annexation in some cases. And really,
that means, in simple terms, taking a property and absorbing it into an existing entity or state. That's what annexation is. Yeah,
and particularly the settlement policy. So right after 1967, you had initially sort of, how to put it, the Israeli government tolerated private people going to settle in the West Bank, and to be fair, some of those people, their parents had lived in the West Bank before the 1947 to 49 war. So like they were, kicked out back then and they went back. Okay, that was how the thing started. But increasingly, since the rise of the Likud party, this has been a government policy of Israel to settle
for sure
with government funds as a kind of security measure. And that, of course, involves the expropriation of Palestinian land, sometimes explicitly, sometimes implicitly. But that's against the Geneva Conventions of 1949. Article 49 forbids it. And so this is the kind of thing that the court gets into. And it says, this is not a legitimate use of the law of occupation. And then they go on further to say, and this is where there's some fracturing of the court, that the occupation itself is per se illegal, and Israel's under an obligation to end it immediately, and and its presence in the occupied territory is wrong. And so that's again where there's some fragmentation, because it's a question of, clearly the law of occupation wasn't intended to allow for 57 years of occupation, and certainly not where it's where you're changing the character. So the changing the character, I think there's unanimous agreement, or mostly unanimous agreement. And that's really wrong. That's a violation of the law of humanitarian, international humanitarian law. But then there's some fragmentation on what's the consequence of that. Does that make the entire occupation ab initio illegal? And
let me stop just for a moment. Go. I don't want to interrupt you in that sentence, but go ahead. So so go ahead.
After you.
All right. So what I was thinking was, so that question, or those series of questions, become relevant. I just want to kind of take it and put it in a larger discourse, because it relates to some of the things, and we won't get into details and phrases, other than I would like to bring up ideas. People say X, Y, or Z, so-and-so has the right to defend itself, or this, this should be thought of X way instead of Y way, whatever the situation is. But what I'm hearing, which I think is critical in terms of providing conceptual infrastructure for just even lay people, and especially lawyers, is that these concepts, which are kind of supposed to be tailored to operate with the mechanics of reality in a meaningful way, actually provide us with a way to think about the larger issue, if we accept international law or get kind of comfortable with the idea of it.
Thank you, Michael. I think that's important. When I teach international law, I often say, look, if you look at this from a historical perspective, from my point of view, there's plenty of blame to go around. There's a lot of bad things that have been done by both sides, really, if you go back to the 1920s, clearly. But international law provides a framework for resolving the thing. And to me, it's, obviously you're always going to have people say that's an unjust framework, but at least we could potentially, it gets us really far down the road to what I think is more or less a workable deal if both sides would work towards it. And
we see that everywhere. I see it in civil. We try to improve things. I did an externship at the state's attorney's office, Cook County. That's an interesting environment. There's a lot of ideas that people have about reform and those sorts of things. So we see this, and we do actually not just the technical work, but we do a little bit of engineering, and we're supposed to be considering this, I think, as lawyers. So this is super helpful in that regard. And we're now very short on time, which I knew we would be. So what do you think are the big takeaways? Because we probably have about 3.5 minutes of good time.
Oh, it's so
left.
short. So it's too bad. There's so much more to say. But basically,
we can do another follow-up on anything you want, so we shouldn't feel rushed, but go ahead. Yeah.
Well, so what is the bottom line? Basically, the court as a whole says the occupation should end immediately. But the American judge, a very good opinion, actually, by former Columbia law professor Sarah Cleveland. I commend that to people. And then there's also a separate opinion by the German, the French, and the Romanian judge that say, we agree that this settlement policy and things like that are violating the international law of war, and that those things are illegal. But they say also, they recognize that there is, in fact, if the occupation ended tomorrow, unconditionally and immediately, this conflict would continue because there is this thing called Hamas, and there is this violent, there's a legitimate security interest that the Israelis have. But in a way, I read the opinion as basically critiquing the approach of this government in particular and its predecessors in doing
this government being
this Israeli government as doing its best to foil the self-determination rights of the Palestinian people. Right. And, an alternative history would have been, okay, we're occupying this land and we have all these enemies and they should make peace with us. But in order to do that, let's have a comprehensive thing which recognizes the legitimate Palestinian rights in the occupied territory. The other very interesting small thing, but it's important, is the American judge and the others point out that treating the Gaza as equivalent to the West Bank is not really accurate, because between 2005 and this last year, and again, the court doesn't decide anything after about October 7th and beyond, was the Gaza occupied? Well, not occupied in the same way the West Bank is occupied, and maybe partially occupied. And you would need kind of a factual determination to say whether the Israeli control over the air and sea, particularly after the Hamas took over, when there's a government that thinks it's at war with Israel, there obviously is some legitimate security interest. But what exactly that is, the court, in the view of these other judges, said, you really don't have the facts. You haven't analyzed the facts to make a well-reasoned determination about exactly what rights they would have when you've partially left some occupied territory and you have a violent group that wants to keep the war going. What a mess.
So part on that. I hear on that. I think the part of sort of, if this is a little bit of a counter that was embedded in the opinion, is that there is still Israeli exercise of control in substantial material, basic life necessity ways over Gaza, which, without getting into detail, was uttered in ways that are part of the ICJ genocide case by top-level Israeli officials about shutting down access to basic life necessities. So it is messy, and but that's all the more reason why I think that international law and a reasoned approach is one of the things that can help make this something we can discuss reasonably. Yeah. And I really thank you for so much you've done in that regard. I can't even begin it. And I think, there's plenty of other stuff to do at your convenience anytime. I know you're busy, and we at the CBA, I think I can speak for everybody at the CBA, saying we really appreciate your time that you're sharing with us.
Thanks for all you're doing for the rule of law, and for reminding us that law is central for democracy. Thanks, Michael.